The Senate will come to order. I need a majority leader, though. Yeah. Here comes Kay Raleigh. I can move it. Need a call. Mr. Majority Leader.
Thank you, Madam President. I move a call of the Senate.
A call of the Senate has been moved and properly sustained. Will the sergeants please close the doors, allow no senators to leave, return those who are absent from the chambers? And Mr. Majors, would you please call the roll?
Aguilar. Aguilar. Balmer. Baumgartner. Brophy. Cadman. Cadman. Crowder. Crowder. Grantham. Guzman. Harvey. Heath. Herpin. Hill. Hodge. John. Johnston. Johnston. Jones. Kafalis. Kerr. King. Lambert. Lundberg. Marble. Marble. Newell. Nicholson. Renfro. Rivera. Roberts. Sheffel. Shorts. Stedman. Doctrop. Todd. Ulibarri. Zenzinger. Aguilar. Cadman. Marble.
Now, Johnston went to pick up his daughter, but that he should have been back by now by the time he told him. We've had people try to call.
Crowder.
Hey, let Lambert know. Somebody said yes, say yes.
It's close.
Did they pull out the calendars off her desk?
No?
Johnson, I think.
So we only got one.
There's 3 left.
Yeah.
Fortunately, it was like this when I saw it. Okay.
Johnston.
Mr. Majority Leader.
Thank you, Madam President. I move the call be raised.
Heard the motion. All in favor say aye. Opposed, no. Ayes have it. The call will be raised. Committee reports.
April 16, 2014, Madam President, the Committee on Judiciary has had in consideration as that hearing on the following appointment recommends the appointment be placed on the consent calendar and confirm. Member of the State Board of Parole, effective April 21st, 2014, for term expiring July 1st, 2014, Marjorie Barbara Lewis, Ph.D. of Denver, Colorado, to fill a vacancy occasioned by the resignation of Anthony Young of Colorado Springs, Colorado, and to serve as a citizen representative appointed. Further, for a term expiring July 1st, 2017, Marjorie Barbara Lewis, Ph.D. of Denver, Colorado, to serve as a citizen representative reappointed. April 16, 2014, Committee on Judiciary, after consideration of the Mayor's Committee recommends the following: House Bill 1061 be referred to the Committee of the Whole with favorable recommendation. April 16, 2014, Committee on Agriculture, Natural Resources, and Energy, after consideration of the Mayor's Committee recommends the following: House Bill 1280 be amended as follows and now so amended before the Committee of the Whole with favorable recommendation. April 16, 2014, Committee on Agriculture, Natural Resources, and Energy, after consideration of the Mayor's Committee recommends the following: House Bill 1180 be amended as follows and now so amended before the Committee on Finance with favorable recommendation. April 16, 2014, Committee on Agriculture, Natural Resources, and Energy, after consideration of the Mayor's Committee recommends the following: House Bill 1159 be referred favorably to the Committee on Finance. April 16, 2014, Committee on Agriculture, Natural Resources, and Energy, after consideration of the Mayor's Committee recommends the following: House Bill 1313 be referred to the Committee of the Whole with favorable recommendation, with the recommendation be placed on the consent calendar. April 16, 2014, Committee on Health and Human Services, after consideration of the Mayor's Committee recommends the following: Senate Bill 155 be amended as follows and now so amended before the Committee on Finance with favorable recommendation. April 16, 2014, Committee on Health and Human Services, after consideration of the Mayor's Committee recommends the following: House Bill 1211 be referred favorably to the Committee on Appropriations. April 16, 2014, Committee on Health and Human Services, after consideration of the Mayor's Committee recommends the following: House Bill 1126 be amended as follows and now so amended before the Committee of the Whole with favorable recommendation. April 16, 2014, Committee on Health and Human Services, after consideration of the Mayor's Committee recommends the following: Senate Bill 162 be referred to the Committee of the Whole with favorable recommendation, with the recommendation be placed on the consent calendar. April 16, 2014, Committee on Health and Human Services, after consideration of the Mayor's Committee recommends the following: Senate Bill 187 be amended as follows and now so amended before the Committee on Appropriations with favorable recommendation.
Introduction of resolutions and memorials.
Senate Joint Resolution 30 by Senators Roberts and Kafalos and Representative Dorr concerning memorializing the Cheyenne and Arapaho people who lost their lives during the Sand Creek Massacre, honoring their descendants, and commemorating the 150th anniversary of that tragic event.
Mr. Majority Leader.
Thank you, Madam President. I move that Senate Joint Resolution 30 lay over till April 28th.
Heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. Senate Joint Resolution 30 will lay over till April 28th.
Senate Joint Resolution 31 by Senator King concerning the establishment of Colorado Safe Schools Month.
Mr. Majority Leader.
Thank you, Madam President. I move Senate Joint Resolution 31 lay over till April 29th.
Heard the motion. All in favor say aye.
Aye.
Opposed, no. Ayes have it. Senate Joint Resolution 31 will lay over till April 29th.
Senate Joint Resolution 32 by Senator King concerning the communications of wildland firefighting best practices between the governments of California and Colorado to aid in the continued advancement of the state's firefighting programs.
Mr. Majority Leader.
Thank you, Madam President. I move Senate Joint Resolution 32 lay over till April 29th.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. Senate Joint Resolution 32 will lay over till April 29th.
House Joint Resolution 1012 by Representatives Melton and Moreno and Senators Ulibarri and Zenzinger concerning a federal minimum wage increase and in connection therewith urging the United States Congress to act.
Mr. Majority Leader.
Thank you, Madam President. I move that House Joint Resolution 1012 lay over till April 23rd.
Heard the motion. All in favor say aye. Aye. Opposed, no. Ayes have it. House Joint Resolution 1012 will lay over till April 23rd.
Senate Joint Memorial 4 by Senator Balmer concerning memorializing former Senator Frank Kemp.
Mr. Majority Leader.
Thank you, Madam President. I move that Senate Joint Memorial 4 lay over till April 23rd.
You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. Senate Joint Memorial 4 will lay over till April 23rd. Introduction of bills.
Senate Bill 197 by Senators Jones and Herpin and Representatives Foote and Crafthar concerning high-performance transportation enterprise transparency.
Transportation.
Senate Bill 198 by Senators Hodge and Schwartz concerning the creation of the Mineral Extraction Study Group.
Agriculture, Natural Resources, and Energy.
Senate Bill 199 by Senator Grantham and Representative Becker concerning amendments to the charter of the town of Georgetown in connection therewith, adding new provisions, modifying existing provisions, and deleting obsolete provisions in the charter.
Local government.
Senate Bill 200 by Senators Jones and King and Representatives Moreno and Rankin concerning authorization for certain alternative fuel vehicles to use high occupancy lanes.
Transportation.
Senate Concurrent Resolution 1 by Senator Crowder submitting to the registered electors of the state of Colorado an amendment to the Colorado Constitution concerning limited gaming in Kiowa County.
State Veterans and Military Affairs.
House Bill 1037 by Representative Landgraf and Senator Baumgartner concerning enforcement of laws against designer drugs in connection therewith, making and reducing appropriations.
Judiciary.
House Bill 1093 by Representative Duran and Senator Newell concerning the establishment of the Creative District Community Loan Fund and in connection therewith, making and reducing appropriations.
Business, Labor, and Technology.
House Bill 1101 by Representative Tyler and Senator Schwartz concerning a partial business personal property tax exemption for community solar gardens.
Finance. General orders, second reading of bills. Senator Stebbins. You've heard the motion. All in favor say aye. Opposed, no. Ayes have it. The Senate will re-resolve into a committee of the whole for purpose of considering general orders, second reading of bills, and Senator Steadman will take the chair. That was nice of you to bring new tulips.
The committee will come to order and the coat rule is relaxed. Mr. Majors, would you please read the title to Senate Bill 124?
Senate Bill 124 by Senator Zenzinger and Representative Fields concerning programs to develop leaders for low-performing public schools.
Senator Zenzinger.
Thank you, Mr. Chair. I move Senate Bill 124 and the Education and Appropriations Committee reports.
To the Education report, please.
Thank you. We added an amendment that added the State Board of Education to the list of entities receiving the success reports for the program. And I urge and I vote.
Is there further discussion on the Education Committee report? Seeing none, the question before the committee is the adoption of the Education report. All in favor, please say aye.
Aye.
Opposed, say no. Ayes have it, and the report is adopted. To the Appropriations report, Senator Zenzinger.
The Appropriations report added the appropriations clause to fund the program.
Any discussion on the Appropriations report? Seeing none, the question before the committee is the adoption of the Appropriations report. All in favor, please say aye. Opposed, say no. Ayes have it. The report is adopted. To the bill, Senator Zenzinger.
Thank you, Mr. Chair. Per the Education Accountability Act of 2009, performance frameworks are used to measure schools and districts' educational success. Districts and schools with the lowest performance fall into the two lowest levels of the state accountability system called priority improvement and turnaround. These schools and districts are given up to 5 years to make bold changes. Districts and schools that fail to make dramatic changes within those 5 years risk actions taken by the state or district. I believe that every child in Colorado deserves to go to a school that meets the state performance expectations, and currently Colorado has over 190 priority improvement or turnaround schools, 16 priority or improvement turnaround districts, and when combined, over 100,000 students. This bill repeals the School Leadership Academy program and creates in its place the School Turnaround Leaderships Development Program administered by the Department of Education. 1/3 of the program will provide funding to assist providers in the design of the turnaround leadership development programs, and 2/3 will be made available in the form of grants to schools, school districts, and/or charter schools for leadership training. Closing turnaround schools and districts really should be the solution of last resort, and we as state policymakers must explore a variety of other solutions before taking that step. Colorado will benefit from nurturing and developing turnaround leadership programs and from supporting aspiring and current leaders to get such training, and I urge and I vote.
Is there further discussion on Senate Bill 124? Seeing none, the question before the committee is the adoption of Senate Bill 124. All in favor, please say aye. Aye. All opposed, say no. No. The ayes have it, and the bill is adopted. Mr. Majors, would you please read the title to Senate Bill 5?
Senate Bill 5 by Senator Ulibarri and Representatives Singer and Duran concerning alternative administrative remedies for the processing of certain wage claims in a connection with amending the provisions for written notices of a wage claim.
Senator Ulibarri.
Thank you, Mr. Chair. I move Senate Bill 5, the Judiciary Committee report, the Finance Committee report, and the Appropriations Committee report.
To the Judiciary Committee report, please.
Thank you, Mr. Chair. The Judiciary Committee report clarified the fine structure and the notice requirements under the bill.
Is there further discussion on the report of the Judiciary Committee? Seeing none, the question before the committee is the adoption of the Judiciary report. All in favor, please say aye.
Aye.
Opposed, say no. Ayes have it, and the report is adopted. To the Finance Committee report, Senator Ulibarri.
Thank you, Mr. Chair. The Finance Committee report clarified specifically the delivery and notice requirements outlined in this act.
Is there any further discussion on the Finance Committee report? Seeing none, the question before the committee is the adoption of the Finance report. All in favor, please say aye.
Aye.
Opposed, say no. Ayes have it, and the report is adopted. To the Appropriations Committee report, Senator Ulibarri.
Thank you, Mr. Chair. The Appropriations Committee report adds the appropriation clause.
Is there any discussion? Seeing none, the question before the committee is the adoption of the Appropriations report. All in favor, please say aye.
Aye.
Opposed, say no. Ayes have it, and the report is adopted. To the bill, Senator Ulibarri.
Thank you, Mr. Chair. I'm going to pass over an amendment.
It appears we have an amendment on the desk. Mr. Majors, would you please read the title to Amendment L012?
Amendment L012, Senate Bill 5 by
Senator
Senator.
Ulibarri.
Thank you, Mr. Chair. This was a technical amendment that came out from the drafter. We had failed to include Section 11 as included in the Finance Committee report. I move L012.
Thank you. Is there any further discussion on Amendment L012? Seeing none, the question before the committee is the adoption of Amendment L012. All in favor, please say aye.
Aye.
Opposed, say no. Ayes have it, and the amendment is adopted. To the bill, Senator Ulibarri.
Thank you, Mr. Chair. I have another amendment to offer with Senator John.
Mr. Majors, would you please read the title to Amendment L011?
Amendment L011 to Senate Bill 5 by Senator
Ulibarri.
Thank you, Mr. Chair. I move L011.
Please proceed. Senator John.
Thank you, Mr. Chair, and I have been working with the good senator on a couple of amendments so that we just don't throw a big net over and capture some of the employers that we really don't want to capture. So on page 5, we are amending, we're striking lines 6 through 10, and what this does is it removes the repeat willful violator. You know, if they have multiple locations, multiple stores, they could get caught in a net that was never intended, and they could actually be a victim. An employer could be a victim of something like this. So we're removing that part. Page 8, we're striking line 18 through 24. Really, the employee should not have to be in this part of the process. If they have not been paid, the department needs to step up and do the job. If they have not been paid and they've asked for payment and they can't get that resolved, they need to go straight to the department. And the department has the authority, and they're the ones that should be doing all notices. The employee should be removed from that process, so we're striking that. And then page 12, line 6, we're striking 84109. And what that is doing is just saying, you know what, it's up to the department if they want to do a waiver of any kind, because they have all the facts. They're the fact finders, and there may be instances where the department very well should take the lead on that and could take the lead on that. So we're striking where they would never be able to do a waiver or a fine waiver, so, or reduce the fine. So those are the three things that we're doing in this amendment.
Senator Ulibarri.
Thank you, Mr. Chair. I consider this a friendly amendment, and thank the good senator who brought it. I'm listed as a co-sponsor on the amendment. Wanted to clarify, urge an aye vote on this. I think it addresses a concern that was raised and that we've heard, which is someone may be treated as a repeat willful violator when they had multiple facilities. That was not the intention. And also we want to make sure that the department has the the ability to make a decision and waive fines if necessary, and if the person acted in good faith, we want that to be an option.
Is there further discussion of Amendment L011? Seeing none, the question before the committee is the adoption of Amendment L011. All in favor, please say aye.
Aye.
All opposed, say no. Ayes have it, and the amendment is adopted. Senator Ulibarri.
Thank you, Mr. Chair. I present you all with Senate Bill 5, the Wage Protection Act. And this is an issue that is near and dear to me and to my constituents, an issue that I think is incredibly important, especially this week during both Passover and Holy Week. I have been approached by constituents who have worked a hard day's work and have expected a fair day's pay and have found themselves completing the work but not receiving the pay that they have earned. And I think that's fundamentally unfair. I said I think this is appropriate, especially for Holy Week and Passover, because Moses led the slaves out of Egypt for work that went unpaid. Stonecutters and people who swept roads and folks who were held in bondage. That was the cry he led, right? Let my people go, let them free. And that work that goes unpaid is something we know all too well in the history of humankind. And that when someone agrees to pay for services rendered, it should be completed. And so this has been a long, long journey, thousands of years long journey. The 8th commandment, long journey, thou shalt not steal, that kind of journey. That's what we're talking about today, where folks agree to do the dignified work of picking a field or building a house or of showing up and flipping burgers, and they should be treated with dignity. I think that's as simple as it gets. Unfortunately, the way that the law has been structured for many, many years, the only option that employees had and employers had is to go to court. And that meant that you had two parties battling over whether or not someone should be paid the wages that they've earned. And it's created a really hostile climate both for workers and employers. Over the summer, I've worked on this issue very closely with employees and employers, the business community, day laborers, and others who have been involved in this issue, and we came to agreement. So I want to make it very clear that the business community is largely neutral on this bill. The Statewide Chamber of Commerce is neutral. The Hispanic Chamber of Commerce is in favor of this bill. The Contractors Association is neutral on this bill. The Colorado Catholic Conference is strongly in support of this bill because of the idea of the dignity of work. And when an employer knows that they can undercut a worker by blatantly, maliciously, not paying that person, and knowing that at the end of the day, after that person has completed work, that they will not pay that person, that they will have an unfair business advantage. So for the roofer that is building and knows that they will never be paying the roofers that they've hired out, they can underbid a contract, which creates an unfair business climate for others who are playing by the rules. It's bad for business, it's bad for workers. Pretty straightforward concept. What this bill does is create an administrative process so folks don't have to end up in court. What they can do is instead call the Colorado Department of Labor and Employment. They can say, here's the issue. CDLE would then investigate the claim. They would mediate the claim without going to court and then say, yes, you're right, you're owed the wages that you've earned, or no, there was no accounting error, actually what you agreed to was X, here's all the records, and you have no case. But instead of ending up in court, you can actually sit two people down, have the conversation, and say, what should happen here? And should we treat folks with dignity? Should we treat them with respect? Pretty simple concept. There have been comments made, and I want to point out, you all should have received this article. It was from the Catholic Register. And Pope Francis addressed the dignity of work during a May 2013 audience on the Feast of St. Joseph the Worker, where he said, work is fundamental to the dignity of a person. It gives one the ability to maintain oneself, one's family, and to contribute to the growth of one's own nation. And if workers go unpaid, it means they lose their dignity. And it's not just their dignity, it's undermining other businesses that are competing fairly. That's what this is about. Simple, basic fairness. Simple, basic fairness. The Wage Protection Act is designed to do exactly that, ensure that workers are paid for the wages that they've earned, nothing more, nothing less. It moves the process largely out of court. And I want to make it clear, we have mirrored the income requirements of small claims court in this administrative procedure. So we're talking about wages that are owed below $7,500 because 97% of the over 5,000 people who call the Department of Labor every year receive less, are asking for wages of less than $7,500. And so these are folks who, when they go unpaid for work that they have completed, are missing a mortgage payment, are unable to feed their kids, are unable to pay their heat. These are the real lived consequences when workers are not paid the wages that they've been earned. This has good economic impacts for our communities. It has been heavily negotiated with the business community to ensure that workers are protected and employers are protected. And we're taking the process out of court and having the ability to investigate, mediate, and ultimately adjudicate any claims that come through where there has been a malicious act. I urge an aye vote on this, colleagues, and would be happy to answer any questions that you may have.
Senator Hill.
Thank you, Mr. Chair. Colleagues, I appreciate the sponsor bringing up the idea of human dignity when it comes to this bill, because that's exactly what this bill is about. Unfortunately, I'd like to show you why this actually hurts and undermines the dignity of the very people we're trying to help. Let me explain this. Many of you know I spent the last 5 years managing the budget for Compassion International. Part of our task was working with about 1.5 million kids in poverty in Latin, South America, Africa, and Asia. And one of the chief components of dignity missing in many of these communities was the ability to stand on your own 2 feet, to have a well-paying job. And so the sponsor's exactly right in understanding the importance of a job in this. However, it's not simple. It's not easy, and this bill is not fair. You see, there are 3 different categories of employers out there. There are good, honest, hardworking employers out there. We have many of them in our state. We're very blessed by that. Then there are a group of folks who are, somewhat sloppy in their accounting. Well-meaning, but they may be sloppy. And then finally, there are a group of people who have proven again and again and again their unwillingness to follow the law, their unwillingness to comply with the basic rules that are set forth in fairness, in rule of law, in equal opportunity. Let's start with that category. Colleagues, do you think a new process and a couple of sheets of paper are going to reform those who have proven again and again and again their unwillingness to follow the law? Do you? Do you think that a sheet of paper is somehow going to take an immoral employer and make them moral? Somehow is a sheet of paper going to take someone who is willing to undermine, to break the law, and to harm those who are working for them? Somehow a piece of paper is not going to solve that, is it? Well, then we have another category of employers out there who are well-meaning but maybe a little bit sloppy. And I'll tell you, I've got a personal experience with that. And I think you'd be shocked to find how difficult it is sometimes just to keep up with the basic laws we've put in place, because we made them so complicated, because we've made them so convoluted, because we've made the cost of compliance so hard. Much to the chagrin of many of you, I'm sure. I taught political science at UCCS last semester. I got paid an exorbitant amount of money to do that, as you can imagine. And I got a note December 31st saying that my pay had not been computed correctly from the University of Colorado. My pay had not been computed correctly, and now I owed $48 back. Well, you see, we had something else starting right about that same time. It turns out it was the Senate session. Turns out I forgot to send $48 back to the University of Colorado. And so I got another letter just recently saying my $48 had been sent to collections. And so now I have to deal with $48 in collections. Now, colleagues, does that mean the University of Colorado is a bad employer simply because it's difficult to comply with all the rules and laws that we've put in place? No, absolutely it doesn't. I don't think anyone will stand up here and say that the University of Colorado is a bad employer. And so what we're doing here is we're putting in a set of rules, pieces of paper, bureaucratic process, and ultimately now we're going to lay it over top of people who mean well but already are struggling to deal with an overly burdensome, an overly complicated, a difficult to comply with tax code. And colleagues, this is where we see that a bill like this is actually going to undermine and hurt the very dignity of those we're trying to help. You see, we live in a world where labor is, well, you can move it around, can't you? You can move it around, and sometimes you could do something here in the United States, or you could outsource it and do it for a lot cheaper somewhere else. And while people don't want to do that, they prize the idea of jobs here in Colorado. The more we do stuff like this, the more we put burdensome, difficult to comply with, high regulation, the more we incentivize employers, right? We combine that with the highest corporate tax rates in the developed world. You combine the regulations, the fees, and the taxes together, and now all of a sudden you're forcing many of these businesses to not hire the people who most need to be hired. Instead, just to keep their doors open, they've got to outsource those jobs. They've got to send those jobs to China. They've got to send those jobs to India. They've got to send those jobs to Indonesia or the Philippines or wherever it might be. So people who now need a job, who need the chance to stand on their own 2 feet, who depend upon this for dignity, guess what? We've just made it harder. And I know we mean well, I know we want to help, but in the process of government trying to help on this front, all we have done is we have increased the burden. We have increased the difficulty of good, honest, hardworking employers from hiring those who most need it. And we've pushed the scales, we've tilted the scales just a little bit more in favor of workers in other countries. We've tilted the scales a little bit farther away from those who don't need a handout but need a hand up, who need to be able to stand on their own 2 feet, and now we've made it a little bit harder. So I appreciate the intention, I appreciate the goal of dignity and standing on our own 2 feet and having our own job and providing for ourselves and our families and making our communities a better spot. But colleagues, unfortunately, this bill doesn't do that. This bill does the opposite.
Senator Jones.
Thank you, Mr. Chair. Well, this bill's about respect for workers. I want you to put yourselves in somebody else's shoes and know that you've worked hard and you expect a paycheck and you don't get it. And then what happens? It's a big problem for you. This bill's genesis came out of Longmont. Representative Gardner and then Representative Singer worked on it many years, and a guy named Bob Norris before that. And what they're getting at is that if you do that work, you get that pay. You cannot break the law and not pay people for their honest work. There's one study which showed that $19 billion in unpaid overtime in the U.S. $19 billion in unpaid overtime. There's another issue. This isn't fair for other businesses. If one business doesn't pay their employees, they can outcompete the ones that are honest businesses. I want you to think of that. Also, it results in lost income to the state. So other taxpayers have to basically subsidize these people that aren't given their pay so that they can pay that tax. And to the whole idea of another piece of paper not doing anything, we're doing a lot of that, folks. Every one of us is running bills to improve the state, we think. That's why we do it. And they do make a difference. Otherwise, we wouldn't be doing this, and otherwise our society wouldn't work. So I thank the sponsor for bringing this. I think it's a great idea. People who work hard should get paid for it. It's very simple. This process has been worked through for years to come to this framework so that business interests would be comfortable with it and the workers would be comfortable with it and people could get the pay due. I ask for a yes vote.
Senator Schwartz.
And thank you, Mr. Chair. And I rise in support of this bill. I want to thank the bill sponsor for really having an appreciation and the patience with a process that brought us a great solution. This is not just a front range issue. This is an issue that affects so many workers throughout the state. And I have had it brought to my attention in my district that some of our most vulnerable workers are not being paid. And they didn't feel they had the recourse. But we are finally allowing that everyone will have recourse, that we will create accountability and transparency around the fact that some employers feel it's okay not to pay some of our vulnerable workers. I think that we have finally found a mechanism that we have access to process that doesn't require going to court. And I think that we have a very valuable solution here.
Senator Balmer.
Thank you, Mr. Chairman. Members, I'm really glad that the distinguished gentleman from Adams County has brought this bill because it has raised an important discussion that we have not yet had this session, and that is to understand how hard employers work to find good employees. For most companies in Colorado, they have a recruiting process where they go and find employees. They actually pay intermediaries to find employees. We've sometimes referred to them as headhunters. You say, oh, headhunters, they just work for, those high-end, expensive professional jobs. No, that's not true, actually. Headhunters, they hire all kinds of employees for companies. So companies spend a lot of money recruiting employees, and then when they hire them, they spend a lot of money training them. These employees to any company are extremely valuable to them. Now, I'm talking about the good employers, which are most employers, the vast majority of employers. And so what this bill will do is actually create friction between the good employers who comply with the law. They follow all the regulations. They follow all the laws. When we pass a law down here, the good employers are finding out about it immediately, and they're changing their HR notebooks, and they're changing their HR policies, and they are immediately complying with the laws because they are good employers. Now, the bad employers out there, the ones that don't follow the law, don't follow the guidelines, don't change their HR notebook when we pass a new law, no amount of fine-tuning of the law, creating that all new regulations on the bad employers, they're not going to do it. They're bad employers. They don't treat their employees right. They don't care about their employees. We got to stop passing laws to treat people that don't follow the law to begin with. Because what we do when we do that is we have great consequences on the good employers. This is going to do nothing, this bill is going to do nothing but increase costs for companies all across Colorado who are struggling right now to keep the employees they've got. Every time we increase costs for those companies, they have to say, oh my gosh, another cost coming from the state. Oh my gosh, I don't know if I can keep the number of employees I got right now. So it is absolutely correct to say that this bill is well-intentioned. Because I know this gentleman from Adams County, he has good intentions. But I'm telling you, this bill will do the exact opposite of what it's purporting to do. So, ladies and gentlemen, I ask for a no vote. And on behalf of all the good employers in Colorado, the 99% that are good employers, thank you for what you're doing every day to grow Colorado. Thank you for everything you're doing to try to restore our economy. And for all the employees in Colorado, I want to say thank you for working so hard. Let's not create friction between the good employers and the good employees. I ask for a no vote. Thank you, Mr. Chairman.
Senator Crowder.
Thank you, Mr. Chair. I just had a question for the sponsor. Come on up. Well, I'm curious about the wage complaint. I'm sorry. The question I had was why would you have an employer hold the records for a period of 3 years? And because I believe that's what puts the burden on business. Would it be not? Would you consider an amendment for a shorter period of time?
Senator Ulibarri.
Thank you, Mr. Chair, and thank you to the good senator from the Valley for his question. This is already standard procedure for those who are maintaining financial records, and it's general operating procedure to maintain those records. One of the reasons why you would maintain those records for a period longer than a day or a month, actually 3 years, is that especially in industries that are particularly vulnerable to wage theft, and I'm thinking maybe the restaurant industry or another, there may be a pattern that has not yet been exposed. The failure to pay tipped wages, the failure to pay overtime wage. And so what may be an $8 infraction 1 week over the course of 3 years can actually be a substantial loss to the employee. And so the idea is that when you're noticed and informed about what happens, there should be the ability to go back to the records and say, let's set the record straight. There are records that you maintain as an employer, which is part of general accounting procedures, general operating procedures that all employers generally follow, which is maintaining those records so they can prove whether or not that they have complied with what they agreed, paying minimum wage, which is both a state and federal law. Maybe it's about following overtime pay. The reason you have that in there is to ensure that you have the record and the employer can CYA.
Senator Crowder.
Thank you, Mr. Chair. Well, before you go, what is actually new and different about this bill than the way it actually is now?
Senator Ulibarri.
Thank you, Mr. Chair. The way it is now is that an employee, if they believe that they have had their wages unfairly withheld or their wages stolen, it is up to the employee to file a letter with their employer and notice their employer that they've had their wages not paid. Under current law, you have 60 days from the point of non-payment to make that notice. And so what that means is oftentimes, and I hear this many times in construction, we have a large construction boom in the north end of Adams County moving into Weld County, is that there may be a subcontractor who's waiting for payment from the contractor, and they say, the check's in the mail, wait 1 second, it's coming, it's coming, it's coming, and the clock is timed out. And so even if they've wanted to be able to move forward, they've been told over and over it's going to be coming in the mail, and once that 60-day clock is timed out, you have no recourse. You have no ability to receive those wages for the hours that you worked. And so I think the claim that was made by 2 previous senators saying, well, let's just let people stand on their own 2 feet. Well, the law, the way it's written today, says if you don't notice within 60 days of the non-payment, not of when you became aware of it, not of when you had some ability to act or some guidance from the state, 60 days from the point of non-payment, you have to have noticed your employer with an official legal notice saying that they have to pay. And if you pass that deadline, you have no recourse, no ability to get the wages that you've earned. The other part is that under current law, someone can call into the Department of Labor and Employment and say, I'm having this issue. And we receive 30,000 calls a year to the Department of Labor and Employment related to wages. Over 5,000 of those calls are related to wage theft. And so when they call in and they say, I'm not sure what I need to do, they ask them if they've met that 60-day deadline. If they haven't, they say, send your employer a letter saying that they owe, and best of luck, and they slap you on the back, and that's the only ability that the Department of Labor has. They can send out a notice that they have received a complaint. They have no ability to issue a citation or adjudication. That's the other big change in this, is that when an employee calls the Department of Labor and Employment and says, this is my situation, and then the Department of Labor and Employment investigates, they realize there has been wage theft, someone has intentionally withheld wages, has done something shady in the books, and they say, you owe this employee this amount of money, that they can actually issue an adjudication letter, which means that they are bound, as a citation, they are bound to pay that money back. Right now, what the Department of Labor can do under current law is say, we have heard of a complaint. Best of luck to both parties. That means that the employee really has no recourse under the law. The only other option is to put this into small claims court, where because of the amount of dollars that people are trying to get back, it's $2,000 for a roofing job, or it's $1,000 for picking a field, and they have not been paid. They have to go to small claims court. No attorney is going to represent those folks in small claims court, so it's individuals taking their employers to court, which is going to be a much more contentious scenario anyway. And so they end up in small claims court where they can battle it out for weeks or months, and then at the end of the day, they're going to be in an issue where they may not have resolution anyway. The idea of having an independent mediator, someone who can investigate the claim, whether or not it's true or not, mediate the potential conflict, and then adjudicate if there is known and it's been proven through all of the information that's been presented that the person is owed wages, then they would have to submit that adjudication letter and ensure that those folks are paid the wages that they've earned.
Senator Crowder.
One more question, leave it alone. The physical note, I was kind of concerned about the extent of that. Can you just kind of elaborate on why, why, in your opinion, why you think it's such a high physical note?
Senator Ulibarri.
Thank you.
Thank you, Mr. Chair, and thank you for the question. The fiscal note is an appropriation to hire on the folks who can do the investigation, mediation, and adjudication of these wage claims. We're talking about 5,000 calls this year where there is no real recourse in the law. We expect that there may be more folks who report when they have an ability actually to get the wages paid that they've earned. And so those numbers are largely extrapolated from the programs that were passed in Texas under, the very very progressive liberal Rick Perry, or in Washington State. These programs have been proven effective to work to ensure that workers are paid the wages that they've earned, and so the caseload is based off of what we anticipate in terms of folks calling in needing the assistance. Right now, the only responsibility of the Department of Labor and Employment is to say, best of luck to you. We have no ability to help you, and you may be out $3,000. I hope you don't end up homeless.
Is there further discussion of Senate Bill 5? Senator Cadman.
Thank you, Mr. Chairman. I think the issue that I'm having with this wage theft bill is the general fund. I mean, that's kind of the wage theft of all of us, because that's what I consider all of the money that we pay in to run the state through our taxes and our fees. And even the fiscal note discloses that most of these issues under the Wage Theft Act can be prosecuted now in 18.4.401 of the Criminal Code. It seems to me we could probably get by with protecting wages by specifically delineating that in the Criminal Code and then requiring restitution under the Criminal Code. I don't think we need $500,000 this year, $650,000 next year, and growing as we do, with basically creating a whole new mini department inside the department when this could be solved under current law with, frankly, just a couple tweaks and hopefully for a whole lot less than this. I'd ask for a no vote.
Senator Ulibarri.
Thank you, Mr. Chair, and thank you to the Minority Leader for his comment. I do want to point out that that was the direction the bill went last year, to put it in the criminal code and criminalize employers, because when an employee steals out of a cash register, that's considered theft. But when an employer steals out of the pocket of an employee by not paying their wages, that's not considered theft, because wages are not considered a thing of value under our Colorado revised statutes. We changed the approach this year because we did not want to criminalize employers. What we understood instead is that employees want to get the wages that they've earned. They've completed the work, they've built the wall, they have painted the house, and they should be paid for the work that they've earned. We shouldn't be locking people up because they refuse to pay. What we should be doing instead is ensuring that workers are paid the wages that they've earned. And in regards to the fiscal impact, I think it's important to note that when people are unpaid, when there is no paycheck issued, it means there is no workers' compensation paid, there is no income tax paid on the wages that weren't paid. Right? But when you actually can go back as the Department of Labor and Employment and ensure that the wages that were earned are paid, it means that those folks are also paying into their fair share. And so when we talk about the potential for this issue, there was a fiscal analysis that was completed earlier this year that indicated that if just 1% of all wages went unpaid, we're talking $1 billion. And then think about the taxes, the workers' compensation, unemployment insurance that's not going paid. That's just for 1% of all wages going unpaid. That means that if we have adequate protections, we're going to make sure that those bad actors are playing by the rules, paying their fair share, and not getting around the other responsibilities that good employers partake in, like paying their taxes or ensuring that their workers are covered by workers' compensation. That's just 1%. Just 1%. This more than pays for itself when we actually have those protections for working people.
Senator Cadman.
Thank you, Mr. Chairman. I appreciate the bill sponsor's response, but I mean, even under the existing criminal code, you could use anything from petty offense all the way up to misdemeanor, depending on the amount and the repetitiveness of the nature of the crime. So it's not like anybody's going to be prosecuted for a felony for making a small error in their wages and their accounting.
Is there further discussion of Senate Bill 5? Seeing none, the question before the committee is the adoption of Senate Bill 5. All in favor, please say aye. Aye. Opposed, say no. No! The ayes have it, and the bill is adopted. Mr. Majors, would you please read the title to Senate Bill 175?
Senate Bill 175 by Senators Carter and Nicholson and Representatives Primavera and McLaughlin concerning freedom from government interference in an individual's reproductive health decisions.
Senator Heath.
Thank you, Mr. Chair. I move we lay over Senate Bill 175 until May 8th.
You've heard the motion. All in favor, please say aye. Aye. Opposed, say no. The ayes have it, and the bill will be laid over as moved by the Majority Leader. Order.
Thank you,
Senator Heath.
Thank you, Mr. Chair. I move we rise and report.
You've heard the motion. All in favor, please say aye. Opposed, say no. The aye has it, and the committee will rise and report.
The Senate will come back to order. Senator Steadman.
Thank you, Madam President. Your committee of the whole has met and had several bills under consideration. I'd ask that the clerk please read the report.
April 16, 2014, Madam President, your committee of the whole being report is under consideration. The following attached bills being second reading thereof makes following recommendations thereon. Senate Bill 133 is amended, Senate Bill 124 is amended, Senate Bill 5 is amended. Passed on second reading in order to gross placed on the calendar for third reading and final passage. Senate Bill 175 laid over until May 8, 2014, retaining its place on the calendar.
Senator Steadman.
Thank you, Madam President. I move the adoption of the report of the committee of the whole.
Is there any discussion? The question for the body is the adoption of the committee of the whole report. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, the committee of the whole report is adopted. Senate Bill 133 is amended, Senate Bill 124 is amended, Senate Bill 5 is amended, passed on second reading and ordered, engrossed, and placed on the calendar for third reading and final passage. Senate Bill 175 laid over until May 8, 2014, and retaining its place on the calendar. Consideration of House amendments to Senate bills. Mr. Majors, would you please read the title to Senate Bill 165?
Senate Bill 165 by Senators Johnston and Kerr and Representatives Murray and Peniston concerning the percentage at which to rate the student academic growth standard for the purpose of licensed personnel performance evaluations in the 2014-15 academic year.
Senator Johnston.
Thank you, Madam President. I move that we concur with House amendments to Senate Bill 165.
That's a proper motion. Please proceed to explain the changes that were made. Senator Johnston.
Thank you, Madam President. And the changes were minor. There was one sentence added by the House that just clarified that while there was district flexibility on how to use the student growth measures, they couldn't make the student growth measures more than 50% of the evaluation, which is already what is current law in Senate Bill 191. So just a clarification there that we believe restates current law, and happy to keep the language in, so we'd ask for concurrence.
Any discussion on the motion to concur? The question before the Senate is for the Senate to concur with House amendments to Senate Bill 165. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused, the Senate concurs with House amendments to Senate Bill 165. Senator Johnston for readoption. Senator Johnston.
Thank you, Madam President. I move that we readopt Senate Bill 165 and ask for an aye vote.
Any discussion? Question is readoption Senate Bill 165. Are there any no votes? With 35 ayes, 0 noes, 0 absent, and 0 excused. Oh, blah, 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 not so much. With Senator Lambert. Other no votes, Senator Harvey. Senator Lundberg. Senator Baumgartner. Senator Brophy. No votes on readoption on Senate Bill 165. With 30 ayes, 5 noes, 0 absent, and 0 excused, Senate Bill 165 is readopted. Any additional co-sponsors? Okay. Conference committees to report.
First report of the First Conference Committee on Senate Bill 131. This report amends the revised bill to the President of the Senate and the Speaker of the House of Representatives. Your First Conference Committee appointed on Senate Bill 131 concerning the removal of certain identifying information from a motor vehicle registration card has met and reports that it has agreed upon the following: that the Senate accede to the House amendments made to the bill as the amendments appear in the revised bill with the following changes. Respectfully submitted, Senators Todd, Jones, and King, and Representatives Wright, Moreno, and Tyler.
It just had to be read.
Oh.
Senator King's ready. We're just reading it, not quite yet, but good to go. Message from the governor.
April 11, 2014, to the Honorable Colorado Senate. Ladies and gentlemen, pursuant to the powers conferred upon me by the Constitution and laws of the state of Colorado, I have the honor to designate, appoint, and submit to your consideration the following member of the State Board of Stock Inspection Commissioners for a term expiring May 1st, 2018, Marla A. Rock of Ray, Colorado, to represent the confinement cattle industry, reappointed. Sincerely, John W. Hickenlooper, Governor.
Agriculture, Natural Resources, and Energy. Announcements. Mr. Majority Leader.
Thank you, Madam Chair.
We do have other announcements.
Yes.
We may have a few more introductions to read across here too, so take your time with your announcement, Senator Herpin.
Thank you, Madam President. I'd just like to remind the El Paso County delegation, Colorado Springs City Council will be with us in the morning for breakfast, 7:45 in room 112.
Thank you. Senator Marble.
Thank you, thank you. Western Day at the Capitol tomorrow. Remember, we are allowed to wear our boots and jeans, and this is to celebrate the economic impact of professional rodeo on the state of Colorado with Senate Joint Resolution 29. So thank you so much, and I can't wait to see who's best dressed.
Members, we're going to stand in recess for just a brief moment. We've got a few more bills to read across the desk, and then we'll be finished. We'll come back to order.
I've been requested to switch a vote on 165.
You don't need to do it. You do notice of intent and do it tomorrow. He's not here. Notice of intent and do it tomorrow. Just do that. Do what? He's not here.
Who is it?
He took off the call. So rather than go through the call, just do notice of intent, and we'll get it. Yeah. I'm one of the sponsors. Let me talk to, wait, let me get Johnson, hang on.
If you can track him down, we can do that after introduction of those two. So let me just start reading these and let him know, and then you can hear it. The Senate has come back to order. Introduction of bills.
Senate Bill 201 by Senator Newell and Representative Singer concerning reestablishing a Child Protection Ombudsman Advisory Work Group to develop a plan for accountable autonomy for the Child Protection Ombudsman Program.
Health and Human Services.
Senate Bill 202 by Senator Kerr concerning modifications to the requirements applicable to the School Energy Loan Program.
Education.
Senate Bill 203 by Senators Lambert and Newell and Representatives May and Gardner concerning the Office of the Respondent Parents Counsel in cases of alleged child abuse or neglect.
Judiciary.
Senate Bill 204 by Senator Marble and Representative Everett concerning the creation of the Student and Teacher Data Privacy and Security Act.
Judiciary.
Senate Bill 205 by Senator Newell and Representative Young concerning the Talent Pipeline Working Group with the State Workforce Development Council and the Department of Labor and Employment.
Education.
Senate Concurrent Resolution 2 by Senators Brophy and Carroll and Representative Nordberg submitting to the registered electors of the state of Colorado an amendment to the Colorado Constitution concerning the protection of electronic data from unreasonable searches and seizures.
Judiciary.
House Bill 1144 by Representative Gardner and Senator Johnston concerning measures to improve the performance of district attorneys in connection therewith making and reducing appropriations.
Appropriations. Mr. Majority Leader.
Thank you, Madam President. I would like on behalf of a colleague to give notice of intent to reconsider Senate Bill 165.
Notice of intent has been given. Any additional announcements? Mr. Majority Leader.
Thank you. Let me just give a little advance notice of a couple of things. Today in appropriations, we did I think 19 bills, if I'm not mistaken. And a lot of those bills we are going to move tomorrow on special orders. The minority leader and I have met, and a number of those bills came out on consent. We'll do those on consent, and some others we'll do just on second reading. So I just want to give you a heads up that tomorrow we will be doing special orders. Also, just an advance notice, this afternoon, Business, Labor, and Technology Committee heard bills, House Bills 1327, 28, 29, 30, and 31. And just to let everybody know, they will be in State Veterans and Military Affairs Committee on Monday, April 21st. So this is just trying to give everybody a little heads up as to where we're going. With that, Madam President, I will move that the Senate adjourn until 9 a.m. Thursday, April 17th. And again, to remind everybody that we will not be working Good Friday, and the Senate will not be in session Good Friday, April 18th. So with that, I renew my motion to adjourn.
Whoopsie, microphone. The motion, I'm assuming, is to adjourn until 9 a.m. tomorrow, Thursday, April 17th.
Yes.
All in favor, say aye. Aye. Opposed, no. Ayes have it. The Senate will adjourn until tomorrow, 9 a.m., Thursday, April 17th.